In this video, I'm going to talk about 3 big mistakes that you need to avoid when you go in front of the judge for a family law matter. My name is Kyle Kaufman. I'm a family law attorney in Wisconsin. I'm going to share with you my framework that should help you develop your case, strategize, think, and be ready to be effective in a courtroom. If you avoid these 3 simple things, you will have success in the court. Why am I sharing this with you? I've been practicing law now for 19 years, and as a young attorney, I found myself making lots of mistakes. And unfortunately, those mistakes caused a result that I did not want. What I discovered is that if I wanted to change the results for my clients, that I needed to change. So regrettably, my framework and skills were developed as a result of making some of these mistakes. I often say there's no such thing as winning and losing. There is only winning and learning. Now, I can assure you, I've always been a professional attorney, and I can also assure you that I'm always driving to be the best. I'm sure that my mistakes were big in my eyes, but to others, they may not have been such a big deal. As a person who has high expectations, though, I am always looking to improve. So for these reasons, I want to share with you the mistakes that I made in hopes that you won't. The practice of law is important. You have to be a dedicated advocate to your client. You need to be responsive, approachable, and accountable. I hope that every lawyer who watches this video feels the same way, and I hope that any person out there who is thinking about doing work with an attorney feels that way. You deserve the best, and your lawyer ought to be striving every day to be the best. So let's jump into the framework, and along the way, I may have a story or two to share. Step number 1 is to remember this. It's called the 7-38-55 rule. What is the 7-38-55 rule? This rule suggests that in face-to-face communication, 7% of meaning is conveyed through words, 38% through tone of voice, and 55% through body language and facial expressions. Here's a more detailed breakdown. 7% words. These are the actual words spoken, contribute only a small percentage to the overall meaning that's conveyed. 38% tone of voice. The way you say the words, including your pitch, your pace, your volume, that all plays a significant role in conveying meaning and emotions. 55% is body language and facial expressions. Things like posture, gestures, eye contact, and facial expressions account for the largest portion of the meaning conveyed. What it really comes down to is first impressions and how you carry yourself. Now, at the outset, let me remind you that your matter is in a courtroom. It is before a judge. Your matter is not being decided in a tavern, a bar, or someone's living room. The environment that you're in, the courtroom, is a serious place, so you need to be a serious person. At the same time, you need to present yourself in a way that is likable. This is a challenge, especially when you are dealing with some of the most important things in your life. Family law matters consist of disputes involving children, finances, property, income, assets, and let's face it, your dignity. So dress, talk, and walk appropriately. Do it in a way that is convincing and commanding and with confidence and clarity. Do it in a way that is nice, accommodating, and persuasive. Think about your body language and your tone. Think about how fast you are speaking. Think about how you are sitting. Are you open or are you closed? Are you acting with a temper? Are you acting with clear thought? What would people say about you if they saw you in this moment? Would they say you seem scared, angry, upset? Or would they say you are happy or sad or energetic? Now, lawyers have an advantage because they get to practice being in a courtroom more often than people that do not practice law. So lots of our mistakes get corrected in a quicker period of time. But for you, what you are really want to think about is, are you acting like yourself or are you trying to be someone else? You want to be yourself because you are going to present yourself in the most natural way. Where I made mistakes as a young lawyer is when I was scared. I was anxious about the outcome in the case and the presentation of the evidence. And in those moments, I can remember myself sitting at the counsel table and I was closed off. My shoulders were turned in. Maybe my head was down. I was not open. I was not facing the court of the witnesses. It was almost as if I was trying to shrink in my seat and get away to leave. Another mistake that I've made is when things did not go my way, using facial expressions or body language to express that, and sometimes not controlling my breathing and raising my heart rate, speaking in a tone that was overly confrontational. Now, we're all humans, and we all have emotions, and it's difficult to control that in every moment, but you must know that people are watching. Think about your experiences in life. If people are acting in a manner where they're yelling or stomping or being rude, then a lot of the times what they're saying does not resonate with you, and it gets us back to the 7-38-55 rule. Essentially, the way that a person presents themselves, the tone of their voice, their body language, how they use their hands, if they maintain eye contact, all of that plays into the message that is being sent to you. And in fact, the words that I'm saying only resonate only about 7% of the time. Now, all of this plays into court because the judge is watching you as the attorney or as the litigant. The judges ask themselves, can I trust what this person is saying? Is this person believable? So your tone, the way you carry yourself and your body language will help convey that message. You simply have to practice before you go to court. If you are not practicing before you go to court and you have an emotional blow-up in front of the judge, you can bet your bottom dollar that the case is not going to go your way. Mistake number 1 will be on you for not controlling your emotions. You must be prepared, you must practice, you must know about your tone and about your body language because the court will pick up on that. And if it's not good, the result for you likely will not be good. The second part of my framework for mistakes that you have to avoid sounds simple, but to this day is still practiced by so many people. It's the mistake of being unprepared for your day in court. Guys, here it is. It's your day in court. It's your chance to tell your story, to present evidence and witnesses. You're going before the judge, the person who's going to decide whether you will have custody or placement of your children, or where and when that will be. The person who will make orders on child support or maintenance orders. The person who will make orders on property division. The person who will make orders on how to file taxes and pay your debts. The judge is important. The decisions that the judge has to make are important. And if you believe that when you come to court, the judge is going to be prepared for you and ready to make a decision based on what you tell the judge that day, you're simply incorrect. Now, I have a phrase that I use with my clients, and it goes something like this. You can bet that your judge is not waking up in the morning saying, gosh, I can't wait to figure out the Smith divorce. No, the judge is hoping that the Smiths have worked it out and that the Smiths have a plan for the judge, that the judge can approve the plan. Now remember, judges see conflict all the time. They want less conflict. They want people to figure it out. These judges are humans and issues can be overwhelming. So what you need to do is make it as easy as possible on the judge. It would be a mistake for you not to be prepared. You want to put it on a silver platter and say, Judge, here it is, and here's a solution. So what you need to do is consider this like a meeting. It's an agenda. You want to lay out your plan and tell the judge, this is what I hope to accomplish today. This is the evidence that's going to support my position, and then you want to execute on your plan. When you go out to dinner, if you think of it this way, you sit down and you're given a menu, and the waiter or waitress says, what would you like for dinner, right? Now, you don't get to just choose anything. You sit there, you look at the menu, and you choose something from the menu. This is what you need to do with the court, your judge. You need to tell the judge, here are the options today. I want you to choose my options, and here's why. It looks good, it sounds good. Now, in addition to your agenda or outline of where you're going with your case, you need to know the facts of your case. Let's use child support as an example. If you come before a judge who has to decide the issue of child support, you need to give the judge very basic information. So, for example, you would want to tell the judge how many children you share with the other party. You need to share with the court your monthly income and the monthly income for the other parent. This takes preparation, right? Because you would need to gather that information before you come to court, and at that actual hearing, you would need to tell the judge about the placement schedule. That is how often the children are living with you and the other parent. You would want to support that with an order or documents that support the placement schedule. Now, you will also want to know how to calculate child support before you go to court. Judges do not love to sit on the bench and do the calculations for you, right? Judges will do it, don't get me wrong. However, you'll win favor with your judge if you've done the calculations in advance and you have those ready for the judge to consider. So again, this is called being prepared. And if you're in a courtroom and the other side is not prepared and does not have information to offer the judge a plan, you will be seen as the more credible person. This happens with attorneys and people who do not have attorneys. I'm still surprised to see attorneys who clearly have not prepared for their day in court, as if they assumed that they would just show up and everyone would just talk and figure it out. Attorneys often fail to arrange for witnesses to come to court, or they don't have the supporting documents or the data, the numbers to support their case. If you are someone who is good at gathering the information and preparing spreadsheets and documents for a court to look at, I encourage you to use those documents, that type of evidence, the demonstrative exhibits, because it helps the court to understand, organize, and collect all the information to make an appropriate decision in your case. Now, as a young attorney, I felt oftentimes unprepared. Frankly, I did not realize how complicated family law actions could be. And the older, more experienced attorneys, they knew the facts of the case inside and out. They were simply ready for every twist and turn, and they had answers or evidence, while I did not, and I seemed to be collecting it in the moment. And that was on me. I had not had enough practice. I did not realize the level of care that it took to truly get to know my client and all their stories and information. What fascinates me today, still to this day, about family law is just that. It's about digging for more and more information and learning, getting to know my clients, all the ins and outs of their lives. You need to know about your kids. You need to know about their employment. You need to know about their income, their assets, their debts, and their liabilities. In fact, you need to know it better than they do. Your clients are counting on you, and you have to be ready to address all aspects of their lives and family law matters. There was a day when I decided I no longer wanted to get my butt kicked in court. And I remember that day. I decided that I would prepare for that day in court. I had enough. I like to settle cases, don't get me wrong. But if they cannot be settled, then I'm ready for trial, and I won't be surprised. Your attorney needs to be prepared. The ones that are not prepared, it's so obvious. You can see it, and it's quite frankly an embarrassment to the practice. The third mistake you need to avoid is when you go in front of a judge is not knowing the law. Now, for people who are not attorneys, this is a little bit harder, but you would be surprised that I've come across many attorneys that simply don't know the law either. These attorneys think that they can speak on the top of their feet and come up with an argument that is fair and equitable and that the court will somehow accept this argument that has no basis in the law. It's truly one of the most frustrating things for me as an experienced family law attorney. It's also hard on my clients. At first, it's confusing because it's hard to track what the attorney is trying to argue. And then you realize they simply do not know what they're talking about. So then as the attorney, it becomes your obligation to educate the court and get the court caught up to speed as to what the law actually is so that the court does not make any mistakes. So how can you learn the law? Well, if you're an attorney, you've gone to law school, and as an attorney, you become familiar with the family code in Wisconsin and the administrative code that deal with family actions. If you are a person who's watching this and you're not an attorney, then you need to consult with an attorney, and if you can't do that, then you're going to have to try to figure it out by studying the law yourself. Of course, hire the attorney would be a good option for you. But it's a dangerous place to be, going into a courtroom without an attorney. Many people believe that family law is based on arguments and that the court just needs to decide things based on how they feel, and they just have so much wide discretion to resolve disputes. That's an inaccurate statement. In fact, family law in Wisconsin is quite organized. Our statutes tell judges what to do in situations to get better results. To help you understand this, I can tell you because it happened to me. I found myself in a situation where, frankly, I did not understand the complete rule as it related to gifted property. You see, in Wisconsin, gifted property, which are gifts from people other than the spouse, can be excluded from the marital estate in a divorce action in certain situations. Now, I understood the basic rule, but when the situation was a little bit more complicated, and we were talking about a gift that was then sold, and the cash was then used to purchase another asset, I, at the time, did not truly understand that that gift could be maintained, even though it transmuted from one gift to cash to another asset. Now, the case worked out just fine for my client, but I can remember being in court and trying to argue my position. And even as I was saying the words, it just did not make sense. Now, thankfully, the court allowed the parties to research the matter further and then provide written arguments and briefs in support of our position. So that's what I did, and I learned quite a bit, and I became educated in that area of the law. Not all attorneys will take the time, however, to truly learn this and correctly cite the law. And if you have an attorney who doesn't understand the law, your case lacks credibility, and the court simply cannot decide the issue correctly because it cannot apply the facts against the law. A common mistake that people make in child custody cases is to suggest that a child who reaches the age of 12 can make a decision on where they would like to live with their mother or their father. In Wisconsin, there's no such law, and you'd be foolish if you came into the courtroom and sat before a judge and said, hey, my child's now 13, and my child can decide. So that right there is a simple example of knowing the law or not, and courts will become defensive if you come into a courtroom and you start making arguments that are not based in the law. By reading the statutes, you can oftentimes tell the judge exactly what to do. I can remember as a young attorney listening to an older attorney. He would routinely say the same thing at the end of his case, and it was so effective. He would allow everyone else to speak, and then the attorney would turn to the judge and say, Judge, in family law actions, there are a lot of emotions, and that makes sense, but I want to remind the court that what the court needs to do is apply the law to the facts in Wisconsin. And the law in Wisconsin is contained in Chapter 767 of the statutes. And in our case, the specific statute is this, and it says this, and as a result, the court must do this. So you can see what the attorney did there. The attorney told the court to not react and make a decision on emotions, but to remember that it was a courtroom and that the decision needed to be based on the law. The attorney was prepared and knew the facts of the law so that the court could make the decision. The statement that the attorney made was just so effective. I would observe that in the courtroom, everyone would suddenly calm down. and realize that while the facts were emotional, that he was right and that the law was the guidepost, the thing that we all needed to look to ultimately determine what to do, like it or not. Everyone's backs would stiffen up, they'd sit up, and they'd read the statutes, and as the attorney went through them, I would watch as the court would nod their head one way or the other, agreeing with the attorney as he went through the statutes. Now, if I try to adopt that model of that attorney, I always remind myself, this is a courtroom, and the facts must be applied against the law, and that the decision will be made based upon the facts and the law. To those of you watching this, you would say, yes, of course, sir, that's so simple. But I'll remind you, in family law where emotions are high, it is difficult sometimes to remember the law. We're talking about children, and we're talking about money, and we're talking about your dignity. So slow down, study the law, bring it into the courtroom, and tell your judge to look at the law as it applies to the facts of your case. It's like a key to the car. Without it, you can't drive. Without the law, the court can't help you. So everyone, avoid the 3 big mistakes that I addressed in this video. Instead of coming out to court and acting inappropriately, remember the rule, 738-55. Use great tone and body language. Be prepared and know the law. If you want to talk to me or one of the other attorneys at HKK Law offices, reach out to us. I encourage you to consult with an attorney about your family law matter. And if you like this video, please let us know. Like, subscribe, or leave a comment below. I will see you next time.